Welcome. You are joining us here today for HR Profiles webinar series. I am Jane McFadden, the client advocate here at HR Profile, making sure all of your employment screening needs are met. Today's presentation is on drug testing, legalized and medicinal marijuana's potential impact on the workplace. Employers screen candidates to avoid bringing liars, cheaters, addicts, and felons into the organization. But if they don't adhere to the stringent and often shifting compliance laws, they can open themselves up to additional legal woes. Compliance can be very confusing for employers. Marijuana is still a Schedule I federally controlled substance, but recently this drug has come into question and has been made legal for medicinal and personal use in some specific states. As more and more states adopt this legislation, we want to make sure employers and HR know the facts. This changing legal landscape has left employers struggling to figure out how it impacts their company and their employees. Thankfully, we are here today to address this very issue and get assistance answering those tough legal questions. You can find a copy of today's presentation in the handout section of your webinar dashboard, and you can also follow along with us on your screen. Janica Pierce-Tucker comes to us from Taft Law, the most prestigious employment law firm in the country, where she was just named partner in January of 2015. Mrs. Tucker represents clients in all aspects of employment and labor law. She advises employers regarding legal planning and policy analysis and formulation, including preparation of employee handbooks. She also represents employers in defense against a broad range of employment claims, including sexual harassment, discrimination, retaliation, and wrongful discharge matters. As a litigator, she is active in other aspects of civil trial as well, appellate litigation and commercial litigation, all as a part of her practice. Tucker received her JD from the Ohio State University College of Law, and since 2009, she has been a member of the Board of Commissioners on Grievances and Discipline for the Supreme Court of Ohio. Tucker was named Columbus Business's first list of 40 under 40 and has been honored as an Ohio Super Lawyer's Rising Star. She believes in leading by example and pushing for what you believe in. You are all in for a real treat learning some best practices for employers who choose to drug test. And she'll cover the basics of policy, practice, and procedure, what medicinal and legalized marijuana mean, and what impact it will have on your company with your employees. If you have questions during the webinar, please type them into the question box, and we will cover them as soon as we can. If there is a problem, feel free to communicate with me in the chat box. I will work to address that issue right away. If your question doesn't get answered during the time allotted, we have an hour. Janica's contact information is in the presentation, and I will also send it to you with your credit certificate and the slides from today's presentation. So, without further ado, here is Miss Janica P. Tucker.
Thank you, Jane, and good afternoon to all the attendees. Today we're going to try to cover as much as we can as it relates to what the impact of the legalization of marijuana may have in the workplace and provide some best practices that you can take away with you as it relates to your drug policies in your workplace, as well as how in which you deal with some of the issues that may arise if you are faced with this situation. Everybody kind of wants to know what will happen in Ohio, specifically as that is the next kind of state that in which marijuana reform is being announced for the ballot in 2016, and so folks are trying to figure out, 2015, folks are trying to figure out, what's going to happen and what impact it will have. Definitely, I don't know all the answers, but I will try to do my best to provide some evidence of what has happened in other jurisdictions and see whether or not that is possible in Ohio. Next slide, please. So in terms of the benefit that you get, employers definitely benefit from drug-free workplaces. It has been proven that in America, we are really in a drug abuse epidemic, where statistics from the National Institute on Drug Abuse suggest that almost 20% of Americans over the age of 12 have reported using a prescriptive drug in a non-medical manner. You also see statistics where that prescription drugs are one of the most commonly abused substances, and about 100 people die every day from unintentional drug overdoses, according to the Cardinal Health Foundation. So it is not surprising that more and more workplaces are looking at testing applicants, as well as providing random testing for employees as a way to improve the safety and productivity of its workforce. We still are seeing positive drug tests continue to eliminate job applicants. So what medical, or what some people may refer to as medicinal marijuana, has created in this atmosphere is an unknown territory, because for so long, and still on the federal level, marijuana is illegal. And so when you start talking about allowing marijuana to be used first as for medicinal purposes, then you have to start having a conversation, as you do with prescription drugs, and how in which you regulate those in the workplace. And so therefore, you then have to look at your population in terms of your employees as to what, how in which you can come up with measures to allow people to take the drugs that are legally prescribed to them, but at the same time make sure that does not, that prescription does not interfere with their ability to perform the essential functions of their job. Next slide. It seems to me, just to give you an overview for those of you who are watching the Ohio Issue 3 marijuana reform, I won't go into too much of the legalese about there is another, as some of you may know, another pending issue that relates to the monopoly that is introduced in this legislation. And so I won't go too much into that, so much as to say that would then, if that is passed where the monopolies are not allowed, that will then affect the ability for Issue 3 to be in effect, because of the language that it provides within the reform. But just to go over how in which some of the provisions in Issue 3, if passed, would affect employment, a couple of things is that the legislation proposes the use of medical marijuana for patients with debilitating medical conditions. And why this is important to employers is because under the American Disabilities Act, it is true that because marijuana is still illegal under federal law, that employers would not necessarily have a duty to accommodate under the ADA for someone to take prescribed marijuana. However, where this becomes a little murky is because even though your duty to accommodate doesn't arise from just the use of medical marijuana, it may arise because of what the marijuana is being used to treat. For example, if sometimes people are prescribed medical marijuana for cancer, well, cancer is recognized as a disability depending on the stage in which it is and the treatment in which one is receiving. And an employer would be obligated to accommodate a person with cancer under the ADA. So those kind of components is kind of how some of these tie in together, even though it's not a direct responsibility from the use of marijuana itself. In addition, under the proposed reform is that it is proposing the legalization of marijuana for personal use in certain amounts for individuals 20 years or 21 years or age of older. So what that really means is that basically for employers is you have to think about you have a population that may be allowed to use it for prescription purposes, but then also you will have a population that is allowed to use what the legislation is describing as recreational use. In that system, that's kind of where your drug test will become very important, because if an individual is allowed to use marijuana just like if they're allowed to use alcohol over the age of 21, and a test is performed that shows that marijuana is in their system, depending on how your drug policy reads, depends on whether or not that employee has violated any workplace policies. Specifically, the reform goes to and prohibits persons from operating vehicles or aircraft or anything of that nature while under the influence of marijuana. I think what will be interesting, though, is determining the impairment level for marijuana use. As you know, with alcohol, there is a certain level in which one is considered, drunk in most states, and intoxicated and unable to operate machinery or a vehicle considered under the influence. But what some of the research is showing as it relates to marijuana is that it impacts people in different ways, and it has a different impact on others, as not everyone is impacted the same from marijuana. So that is going to be something I think that will be looked at, and if passed, possibly litigated as it relates to what impairment means under marijuana and how in which that will be imposed. Next slide. So what we have to think about for purposes of employers is that I believe that in most states that have approved through their legislation the legalizing marijuana, whether it's for medicinal or recreational purposes, specifically provide language that talks about how this interplays with the employment or your workforce. And basically, most of the languages that I see as what the Ohio reform is offering is that it is not, the amendment is not intended to require an employer to permit or accommodate the possession or use of marijuana in the workplace. So what that means is that the message to the employers is that we're not asking for you to accommodate someone's use of the drug. However, they talk about specifically in the language in Ohio that there may be an exception for a patient that has a medical marijuana certification, that they may self-administer the medical marijuana to themselves. And so you then go into the realm of how do you treat other employees as it relates to when they are given a prescription such as a Vicodin or a Percocet that may impact their ability to perform their job. And the same would have to go with marijuana, but it goes back to the discussion that I was just having, is that how do you define impairment, and whether or not if that person is able to inhale the marijuana on their break and then come back immediately to work. Some may say they can, and how in which the employer is supposed to react to that, I think, will be a major question of how you of some things that we will see coming forward. Also, you have to appreciate that sometimes if in most situations, if an employee is allowed to or given a prescription for medicinal marijuana, then most states are implementing what they call a a user card or registration card, and that card is certified, and it could possibly come through the doctor's office and then certified with the state as a person who is allowed to have marijuana on their person for the specific purposes of their treatment regimen. And so when you're looking at that, and then you have possibly a drug policy in place that may conduct some random testing, then you have to consider whether the simple presence of the marijuana in the system, is that sufficient enough to justify a violation of the policy, or do you want to define the policy that it has to be considered an impairment of the drug in order to be a violation? And I say that because I think that the conversation is going to revolve around how and which employers treat other prescribed medication in their drug-free policies, or any kind of policy that you have in place at your workplace. So what that means is that if you allow an employee who may have a prescription for a muscle relaxer, and in some instances people can take muscle relaxers, and then say, for instance, then that person is then drug tested. Well, some components of that muscle relaxer may show up on that drug test and give an indicator of a positive test. And then the question becomes how in which the employer would treat that employee that is on the muscle relaxer would have to treat the employee that is receiving medicinal marijuana as a prescription in the same manner, relating whether or not that person will fail the test. Next slide. So currently in the United States, we have about 23 states and the District of Columbia that currently has medicinal marijuana laws. Those states include Alaska, Arizona, California, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Montana, Nevada, New Hampshire, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, and Washington. In those 23 states in the District of Columbia, there is statutory language that authorize individuals with qualifying medical conditions to legally use marijuana. And so in addition to those 23 states, Colorado, Washington, Alaska, Oregon, and the District of Columbia have legalized marijuana for recreational use. And it seems to be that, and why I think that we're seeing a lot of reform in this area is because it seems to be that studies are showing that marijuana continues to be the drug of choice, meaning that most people, if they are being arrested for either the use and or sale of drugs, it usually is more common to be marijuana. And so when they talk about these class of people who would be considered registered users, I think that creates maybe some issues of we could see some protections that may come out as it relates to a class of protected registered users, specifically for medical conditions. Most of the legislation prohibits the arrest or prosecution of the authorized use or sale or possession of the drug. And I think that's important for employers to note that basically I can simply say that the law would prohibit someone from going to jail, but the law does not necessarily protect someone from their employment. For example, in the Illinois statute, it specifically states, nothing in this act shall limit an employer from disciplining a registered qualified patient for violating a workplace drug policy. In Montana, it specifically says that it prohibits an employer from including in any contract a provision prohibiting the use of marijuana for a debilitating medical condition. or permit a cause of action against an employer for risk, wrongful discharge, or discrimination. So therefore, what Montana is saying, look, employer, you still have the right to have a drug-free workplace if you so desire, as well as acknowledging that in any kind of employment agreement that if you are an employee at this company, that you cannot use marijuana. Next slide. So the question becomes a little bit about what is it and how is it used. In most instances, it is used as a medical therapy to treat disease or alleviate symptoms. It has been recognized as a way to treat nausea and a way to improve appetite. When you have like a condition, when a person has a condition in which those are high symptoms where they lose their appetite, they're highly nauseous, and so marijuana has been proven to assist in those areas as a therapeutic way versus maybe some other type of drug. It is also being seen that in these states and where it is legal that folks are being told to always have on their person a card that's given to them, as I described earlier, from their doctor that basically shows that they have a right to have the marijuana on their person. And I think this is more key in the states in which it's only for medicinal purposes. I think where the states where it's both medicinal and recreational use, you have a component there where people necessarily will not have to have a card because everyone who chooses to use it is allowed to have a certain amount on this person without it being a violation of the law. Next slide. It seems that most of the reasons or why it's being prescribed is pain. A lot of time is given to folks with multiple sclerosis that have for muscle spasms. We talked about the nausea. Crohn's disease patients are prescribed, and glaucoma. But I want to bring your attention to the fact that, as I explained earlier, that the issue is for employers is that even though you may be in a situation, or we're in a state now, like in Ohio, where it's not legal, if an employer is somehow put on notice that, hey, I have been given a prescription for marijuana for my multiple sclerosis, okay, there is a conversation that can be had as it relates to if you have one in place, the drug, maybe there's a drug-free workplace policy in place or any kind of drug policy in place. But now the employer has also been put on notice, if not known before, that this employee does have a disability, i.e. multiple sclerosis, that then may bring in some other issues of accommodation that may open up the employer's obligation to engage in the interactive process. And so that is why this situation gets a little murky, because it just doesn't stop at the fact of saying, oh, well, you can't take, you're not allowed to use marijuana here, but then because it then may open up the door for other things in which an employer is required to accommodate under the ADA for the recognized disability. Next slide. The common thing that I think employers should know as it relates to medicinal marijuana and how it is taken is because, you know, I know a lot of times people may visualize, okay, are people just going to be, you know, taking their break like folks take a smoke break and then they're just outside smoking pot? And I can understand how that could be a concern. And because, you know, it is used, it can be smoked, it can be vaporized, it can be eaten. I've seen that given in a way. I've known cancer patients who are given kind of recipes as to how to put it in their food, and also use as a liquid extract. Some of the side effects, though, are what can be concerning to employers, because those side effects may impact one's ability to perform their essential functions of their job, such as dizziness, drowsiness, short-term memory loss. Some of the most serious side effects that have been noted are severe anxiety and psychosis. So those kind of things are definitely can be a concern and raise an issue for employers as it relates to not only one's work performance, but depending on the job, the safety of the employee and those around them. So these are all kind of factors one should consider when looking at some of the effects that medicinal marijuana can have on an employee. Next slide. So as you can imagine, there are lawsuits that are kind of popping up around the country as it relates to, and specifically in the employment context, as to what rights are protected, if any, for employees who may be using medical marijuana and are then receive an adverse employment action, whether it's a termination or a discipline because of a discovery of their use of the drugs. For example, in a case out of Colorado in which there was a recent decision in June of this year that basically Mr. Coates was an employee and he was a quadriplegic, and he had been given a prescription for marijuana, and he was a customer for his painful muscle spasms that he experienced because of his quadriplegia. And he was a customer service representative in the company for Dish Network, and he had been there for about 3 years. And so what happened was Dish had a random drug testing, and they tested Mr. Coates, and he tested positive for the test. And so they terminated him because that was a violation of their drug-free workplace that specifically said that, you cannot have drugs in your system when tested. And he then filed a wrongful termination claim under the Colorado statute that basically allowed for the use of medicinal marijuana. What made this case interesting, next slide please, what made this case interesting is that smoking marijuana was not a lawful activity within the meaning of the statute, is what the Colorado Court of Appeals said, because they said that the activity must be legal under federal and state law. So where Mr. Coates got into a problem was that it was legal under Colorado, but it was not legal under any federal law. And so therefore, within the meaning of the statute, they were allowed to permitted to terminate the employee for the marijuana use. The court even went further and said that even if the employee doesn't use the marijuana on the employer's premises and is not under the influence while at work, but still showed up in the drug test as positive, then that employee can still be terminated if it's a violation of the workplace policies. So next slide. So I think 2 points to take away from that particular case is that, if it's a violation of the drug policy and it's being applied in the same manner to everyone involved, then therefore the employer would be justified in its actions taken to terminate the employee. Another case I'd like to bring your attention to is Cases versus Walmart Stores, and that is a Sixth Circuit case, that was decided in 2012, and that Sixth Circuit is the district that covers Ohio. But there was an employee with an inoperable brain tumor, and he had a card that allowed him to use marijuana for his symptoms associated with his brain tumor, and he was tested positive at work and was terminated. And there too, the court said, look, you are allowed to, under the state in which you are in, allowed to use the marijuana for your symptoms. However, you're not allowed to, and that was in Michigan, you're not allowed to then violate the policy at work because the Michigan statute did not regulate private employment. And the Michigan statute was only designed to protect individuals from prosecution and other adverse action by the state. So the court dismissed his wrongful discharge claim. Next slide. So a couple of takeaways that I'm seeing in some of the cases that are popping up around the country as it relates to medicinal marijuana is that they don't provide a protected status to patients. That's important because, as you may well aware know, that in a lot of protections that are given by the federal government, we come up what we call in employment law is protected classes. These protected classes such as women, or you're protected on the basis of your sex, or you're protected on the basis of your race, or your age, or disability. It is not appearing that right now, with the few cases that are happening in this area, that individuals are being recognized as a protected class because of their ability to use marijuana. And so in some ways that's a good thing, and as it relates to how in which some of the agencies may try to enforce some provisions that may come out of some of these marijuana laws. It seems as though that state Supreme Courts in these areas of the cases that have come before the courts, that they are upholding, in most cases, the company's decision to fire the employees, even if they're using marijuana outside the office, if they are then shown a positive test in their drug policy that is a violation. So I think from an employer standpoint, then that will help, and when you're trying to enforce your policies, if you now have to consider marijuana as a legal drug. Next slide. As I've kind of hit on a couple of things that, the effects of drug use, whether it's marijuana or any other drug, can have impacts on an employee and their work environment, such as decreased productivity, poor performance, increased absenteeism, safety hazards, and a cost in health insurance, because how that correlates is because it may bring about other issues that require the employee to seek treatment that otherwise wouldn't be there, especially when you start getting into drug abuse and the impacts that have on one's health. Next slide. So some laws that employees should consider and how they may be impacted by the legalization of marijuana. We've talked a lot about the ADA because I think that is probably the biggest one, not so much because the use of marijuana, as I've said before, is not regulated by marijuana, but but more importantly, the disability in which the marijuana is used to treat that whatever underlying condition. Looking specifically, since it is true that marijuana has not been determined legal under the federal laws, then some of your state civil rights acts may take a position as it relates to how employees are being treated in specific states that recognize the legalization of marijuana, whether it's for medicinal purposes or recreational use. Under the Family Medical Leave Act, there may be some implications depending on if people have to take, for example, if in some policies that I've written in which people may have to take a prescribed drug that may alter their mental capacity or affect their ability to perform because maybe they get sleepy or whatever. sometimes then when that person is having to take that drug, may take leave. That leave may be a sick leave. That leave may be recognized as intermittent leave under the FMLA. And so that may come into play when a person is giving a prescription for medicinal marijuana, and how in which that may impact their ability to perform. Another key thing is that for those of you who may have unions in your workplace, I would think that this particular provision may be a contention in the collective bargaining process as it relates to the impairment level, specifically when talking about the positive or negative test of a drug test, the negative or positive results of a drug test, and whether or not when that impairment would suffice to qualify as a positive test to serve as a violation of the policy. And so those type of topics may come up when one is talking about the collective bargaining process and what will happen to an employee. Next slide. So as I mentioned before, under the ADA, as I said, marijuana is not legal, so you're not allowed to accommodate. Your employer may be on notice, though, of an employee's disability if the employee inquires about the company's policy regarding the use of medicinal marijuana to treat his or her condition. Next slide. One thing to bring to your attention, though, is that it is key in these circumstances that employers treat those who do illegal drugs and alcohol users to the same performance and behavior standards that are applicable to all employees. So, and also another thing to note is that if there is a test for illegal drugs that reveals the presence of legally prescribed medication, whether it's marijuana or not, if marijuana is legal in your jurisdiction, then that is a confidential medical record and should be treated as such and should not be disclosed to people. That should only be disclosed on an as-needed basis for those who the information is necessary, but definitely HIPAA and other things should be followed to maintain the confidentiality of the record. Another thing to note is that a lot of times people start, so it becomes the question of how can you make any kind of inquiries of employees as it relates to, specifics if you want to talk about drug use of any of that or anything in that nature. And I think that asking an employee about current illegal drug use is not prohibited. However, it could be prohibited to ask an employee whether he or she is currently taking any prescription drugs or medication, asking an employee whether he or she has taken any such drugs or medications in the past, or monitoring an employee of taking such medication, because those type of issues get into the realm of, they definitely get into the realm of some protections that employees are given under the ADA and as it relates to their own medical privacy. Now, clearly there are exceptions to that as it relates to public safety. So, for example, a police department could require armed officers to report when they are taking medications that may affect their ability to use a firearm or to perform other essential functions of their job. But I think that employers may have a hard time asking that same question of an administrative assistant whose job may not impact the public safety or the safety of others in the workplace. Next slide. So, kind of what now, some practical implications that are currently, as of right now, no use of marijuana is legal in Ohio, medicinal or recreational, but In Ohio, companies don't have an obligation to accommodate an employee's medicinal marijuana use, and the employee is not exempted from the zero tolerance drug policy. And I note that this may change soon in light of the fact if issue 3 passes. But I think that human resources personnel should start to get in place kind of a way in which that they will respond to the legalization of marijuana and how in which that will be dealt with in the workplace. Next slide. And this slide just gives an overview, and I won't go over that so we can get into the policies a little bit as to what would happen if issue 3 passes, and I kind of talked about that already. Next slide. The Drug-Free Workplace Act, it promotes, and that's on the federal level, it promotes safety and accountability, and it's required that entities that receive federal contracts with a value of more than $100,000 or receive any federal grant to maintain a drug-free workplace. And so they have to have a policy in place that subjects their employees to discipline or termination. For example, what we're talking about, if they were to use marijuana while on the job or show up for work under the influence, regardless of whether or not marijuana is permitted by state law. So this is specifically an instance in which the federal law would trump the state law as it relates to federal contractors. Next slide. Specifically also in the Department of Transportation, it requires drug and alcohol testing of safety-sensitive transportation employees. So those are folks that operate your aircraft and your truck drivers and your railroad operators, and they too would not be excused under any test because they're an essential function of their employment is not to use drugs, and so therefore they too would be found in violation of a policy even if the state in which they are employed allows for the use of medicinal or recreational use of marijuana. Next slide. So under both federal and state laws, employers generally have a duty to provide a safe workplace for all employees. So the deal here, I think, is not for these reforms that are popping up all over the country to in any way impose upon employers a hardship in trying to, fulfill their obligation of providing a safe workplace. And I think that most of the legislation is trying not to write in it any protections that employees may feel they have as a right of being an employee, but you still have to follow the rules that are in place as it relates to any drug use. Next slide. So kind of talking about a little bit, what should a drug policy contain in your workplace? The first thing is that, understand what is the reason for the policy. Why does your workplace want to have a policy that addresses drugs? And the first is that, it is important for employers to discover and correct drug and alcohol abuse or use in the workplace and deter it at all costs, because that can lead to so many things that can be problematic for the employer. Identify what is it designed to do. It is definitely designed to enforce, to promote the safety of employees and also the well-being of employees. It puts the employees on notice at the time of hiring as to what is expected of them. I will say a note, I've definitely had situations where I've advised clients that didn't, say for instance, they didn't have a drug-free workplace policy in place and then they transitioned into one. I will note that when an employer is considering to do such things, they need to make sure that they give the employees advance notice that that will be taking place before they start testing, because you don't want to be in a situation where you announce that you're enforcing or implementing a new drug-free workplace and you start testing the next day, because you may be surprised of who will be positive. So you want to make sure that you give a enough notice period to allow the employees that are in place to make some corrections and get some if they have drugs and they're using drugs, to get that out of their system before the employees start testing. But there is nothing wrong with transitioning into a drug-free workplace policy. Make sure the policy identifies what substance and behaviors are prohibited, what legal drugs are allowed on the job. Anything, sometimes I've seen policies be as specific as, yes, it's okay to take an aspirin, it's okay to take a Tylenol, and define how in which the employer will deal with those who are on prescription drugs that may impair the individual at some point. And precisely lay out what will happen if the employee violates the policy, and make sure that your policy is being followed. I cannot stress that enough, that you have to follow the policy in order to kind of make the policy what it is. Because if people know, oh yeah, I might get caught, but they're not going to do anything to me. The problem is that when you don't do something to somebody else and you do it to another, that opens up the employer to risk of other reasons as to why they chose to not apply the policy fairly, and especially if there is an issue with one of the individuals being in a protected class, that may open up some discrimination claims. And understand that in the policy there needs to be a definition or a description of what we like to describe as an indicia of reasonable suspension. So you want to have training in place that kind of gets your supervisors equipped to notice signs of impairment. And like I said, it's not always easy, but sometimes what you have is you have an individual who says, I'm okay, and then you have some who are impaired, they're acting so irrational that anybody can see that there's a problem there. So you need to have some training in place for your supervisors or directors or whomever who's dealing directly with employees, to be able to have an idea as to, we may have a problem here, and determine whether that person needs to be tested. And there's a question about, is it possible that a person taking prescription drugs be positive on their drugs, on the drug test? It could be, because some of the higher volume, or not higher volume, but some of the higher dosage of pain medication, and depending on what your drug test is testing for, kind of what's on that panel or what they're testing for, could indicate a positive test. For example, some people who, if an employee is taking Percocet, and say for instance they took a Percocet before they left for work, then they took another Percocet, 2 hours later, then they took another one, 3 hours later. Well, that high dosage of taking that drug, and then it may show up on their drug test, and not necessarily that will make it positive, but then that's when the policy has to say, look, if you have a prescription that you show us that you have a prescription for this drug, yes, it's a positive test, but it's not a violation of our policy because you have it. However, it may still be a violation of the policy if that individual is impaired, or their behavior is something that's not allowed while under the influence of that drug. So definitely it can show up as positive. You have to, for example, there may be instances too that you need to provide for in the policies where you're dealing with safety-sensitive positions, and those folks kind of are held to a higher standard in some sense, and they will be subject to random testing in some cases, especially under the Drug-Free Workplace Act and some of their specific language that has to be in their policies that relates to those safety-sensitive positions and how and which one is required to have a random drug test, especially if suspicious behavior is noted. Next slide. Your policy needs to also look at what, if, for example, someone has a positive test and they want to appeal it, if they, because maybe they have some kind of justification for whatever drug showed up in the screen, and so there needs to be an explanation of how that process will be in place. There needs to be, if the employer offers what has been very common, referred to as the wellness policies or the wellness program, or employee assistance programs to help people maybe need some counseling or anything like that with drug abuse, those kind of things can be laid out in the policies. And then written in effect that a lot of times people say, well, you know, I'll just do this and then it's not considered a violation. It may still be a violation of the policy, but then there may be a program in place that, hey, if you do X, Y, and Z, then, you know, the employer will be considered not terminating you. Also have a provision within the policy that talks about how this interacts with workers' compensation. I know in Ohio there is a discount that employers can get if they comply with a drug-free workplace program that's administered under the workers' compensation, and it talks about specific language that has to be in there. And so if you're an employer that participates in that or seeks a discount in that nature in your jurisdiction, you want to have policy language within your drug policy at work as to how that interacts with your workers' compensation system. Talking about the confidentiality of the information that you receive through this process is important so that employees know going in what's protected and what's not protected, and how that making sure that the policy is fair and consistent and applied across the board. And also, too, is that you have be very specific about the consequences that may happen. Like, for example, like I was talking about, like if you're in a trucking industry, and so definitely folks who have a CDL license are kind of held to a higher standard than those who not, because of their position. And so there are certain things that they have to comply with, and certain language that is required, and policies that are administered to those folks that fall under the federal contracting provisions as required by the Drug-Free Workplace Act, that you want to make sure is covered if that is applicable to your employment. Next slide. And so just to highlight, too, that, as I was saying, there are some drug-free safety program policies that if you are a participate in any of those or desire to be a participate in any of those, that usually are administered through your BWC, and you get pretty significant premium discounts, but there is a process in place, and there's also some requirements that are necessary, such as what the program requires, and specifically is a policy and a procedure, operational procedures as to how the policy will be implementing. There is a requirement that records must be kept in a certain way, in a certain fashion, and in a certain time period to cover as it relates to positive test results or anything received. And specifically, there needs to be employee education and supervisor training. I think that it is definitely being pushed that supervisors, I have done training before where we have had a entity come in and train with us. So our job is kind of to train folks how to handle it, the policies from an employment perspective. But then there is the medical side of this, of signs of impairments and how to deal with those things and how to kind of counsel employees, and how to refer folks to, if it's available, your employee assistance plan. And so all those things are in place. Next slide. So some best practices I hope that to leave you with here in our last few minutes is to, while we're kind of in the middle road where some states are doing it and some states are not, and it's not legal on the federal law level, continue to comply with the federal regulations. I think that will offer some protection for employers, especially depending on what sector you're in. The employers are still in control, and you're free to decide what your policies will look like, whether you go for a straight drug-free workplace where there is no drugs allowed, or whether you go to these drugs are not allowed, providing a list or a system, and then talking about whether or not you will entertain random testing, or if you will just do testing at the beginning of employment, or at the end of or during the employment process. And make sure that the policy prohibits the use of marijuana in and outside the workplace, because that will cover the employer if the employer does pre-employment and random testing. Because if you don't specifically say that prohibits the use of marijuana outside the workplace, then it's hard for you to then say it's a violation of our policy because we randomly tested you today and you were positive. So make sure that your language is specific as it relates to when a person can or cannot use marijuana, especially if they're in a state in which recreational use is permitted. And then talk about whether or not you want to ban all employee drug use or define impairment. And as I stated earlier, I think that will be a challenge, but hopefully the legislation that goes into effect in these states will give us some guidance as it relates to what is considered impaired for purposes of marijuana, and then that way you're at least able to have an indicator and not just a subjective analysis. Next slide. Make sure to communicate and clearly state the expectations. Train your managers about the confidentiality as it relates to sensitive employee information. You do not want that information being out because it is a medical record, because some of the accommodations may touch upon one's underlying disabilities that is definitely protected under the ADA, and then you don't want to be dealing with HIPAA violations or any other kind of breach of confidentiality of information. I recognize that a lot of companies are all over in different states, so you have to appreciate and know what your laws are of the state where you have employees, so you know how to, if your policy needs to be adjusted or amended to account for the places in which you have employees. Be mindful of the information the company may receive from employees, because, like I said, that may put the employee on notice of a disability that later the employee will have to accommodate for another reason other than a prescription for marijuana. Next slide. So I know we covered a lot of information, but I hope that this at least gave you an overview of what may come as it relates to the legalization of marijuana, specifically in Ohio, and as it relates to what we have to do. There is a question that asks, should you use hair or urine test, or what test did you use? I will tell you that from my experience, I worked at General Motors for a few years, and urine analysis are common because they are the most cheapest. But hair analysis is probably the best indicator. Because what it does is that it stays in your hair longer than it is in your urine. However, it is much more common for folks to use urine analysis during as a random drug testing, and then hair and those types and that test is possibly used more at the pre-employment stage. Another question that pops up, and I'll answer quickly, if an employee has a medical prescription, when should they disclose that to the employer? It depends on what the drug policy says. And it also depends on, they're not automatically obligated to tell their employer that they are on a prescription drug. Now, if that drug impacts their ability to perform, like they're sleepy or they're unable to work, then your drug policy should address that, because then the employee then has to take sick leave or take some type of leave while they're on that medication. Or, you know, if then they require a break or something of that nature. So that is something that you could have in place. I think we have time for one more that says, as legalization expands to additional states, do you anticipate it becoming a protected class? What can be expected down the road? As I stated before, you know, definitely we may see the registered users. I think for medicinal purposes, we may be looking at a protected class because most of the time, if you're giving it for medicinal purposes, then it relates to an underlying disability. But I don't think we will see that type of movement until the federal government takes a stand as to what marijuana means on a federal level. States can continue to do this, but I think as more and more states do it, then I think that will get the federal system involved, and then that is kind of where it may grow. Now, on a state level, though, as I alluded to, some of your state civil rights agencies may take a position on that, but I think they would be kind of looking to get a little bit more states in place with these to kind of get an idea of what the federal government is going to do. If you definitely see President Obama talking about, he has definitely kind of been talking about marijuana reform as it relates to people who are in jail for marijuana, have been in jail for long periods of time. And so we may see something on the federal front, but as of right now, there is nothing specifically on the horizon. So I'd like to thank you so much for your attention. I think Jane indicated that if there are more questions that we were not able to get to, we will definitely answer those questions for you. In a response, you have my contact information. Please feel free to send me an email or give me a call and to talk about anything I discussed, and have a great afternoon.
Perfect. Thank you so much, Janica. I mean, my head is about to explode with all the information that we just got. I think it's great. So thank you so much for taking your time and helping us understand this legal landscape of what it is. You know, that is all that we have for today. So thank you all for spending an hour with us. Make sure that you join us in November. We're going to do a year in review of employment screening, and that will be November 18th at 2 p.m. The link to register will be available in the follow-up email that I'll be sending along with the slides from today's presentation and your certificate. So we look forward to seeing you next time. Thank you so much. Have a great day. Bye.